Councils for number 3, 4, and 5.
Lesi sicelo siyaphikiswa abameli bukaMsolwa wesithathu wesine nowesihlanu.
The gravamen of the application by the state is that they want to recall Lieutenant Colonel Steyn, the reason being for him to clarify only two aspects that appear on page 23, 26, and 27 of his affidavit.
Kuthiwa ke isizathu ke esokuthi ufakazi lona uyacela ukuthi abuyiswe ukuze azochaza okubili kwaloku akubhale ku-affidavit yakhe.
In support of this application, the state alleges that Exhibit O, 1 in brackets, Ms. Withelingham's affidavit dated the 16th of May, 2024, which is Exhibit J1, she sets out the transactions for two telephone calls, namely one made on the 2nd of August 2014 and one made also on the 15th of October 2014 between Ms. Khumalo's number, and these calls were received by allegedly or made by accused number 5, and further that Lieutenant Steyn locates the two calls at the time as the same as those which are reflected in section 205 downloads of the cell phone numbers.
So lapha ku isikhombisweni o tho umama uVithelingam uthi kukhona ke izingcingo ezimbili olunye lamhla 2 ku-August 2014 olunye nomhla 15 ku-October 2014 ezenziwa ke umsolo wesihlanu eshayela uKelly Khumalo, kodwa ke uColonel Steyn ubeka lezi ngcingo kungelezi ke ezavezwa ngaphansi kulombiko ophume ngesicelo sika section 205 sicela amafoni.
It is pertinent to mention that Lieutenant Colonel Steyn testified, I think in August last year, and that Ms. Pinky Withelingam testified in July this year.
Ukufanele kuphinde kukhunjulwe ukuthi uBaba Steyn waletha ubufakazi bakhe ngo-August kulonyaka odlule. Ms. Pinky Withelingam yena ulethe ubufakazi bakhe ngoJuly wanonyaka.
The state differentiates between the duties and titles as to what Ms. Pinky Withelingham's capacity is, and they refer to her as a supervisor in the Forensic Liaison Service section of Vodacom, whilst Steyn is apparently referred to as an analyst of cell phone information.
Kuthiwa ke umshoshisi yena ubona kukhona umehluko phakathi kwemisebenzi owenziwa umama uVithelingam lo kuthiwa ke yena usupervisor we-Forensic Liaison section yase Vodacom, kodwa ke uSteyn yena umsebenzi wakhe ukuhlaziya amafoni.
Mr. Baloyi, on behalf of the state, argues that this distinction is very vital because it is the one that allegedly brings about a dichotomy regarding its scope as practiced by either Ms. Pinky Wallingham and Lieutenant Stein, and says this very difference in the description of the expertise exercised by these two different witnesses has given rise to confusion, which the state says entails matters which are not clarified, and which the state further says when it argues that the defense says there is a contradiction relating to the two aspects of these two telephone calls.
Kuthiwa-ke lana-ke umshushisi yena uthi-ke lokhu kwehlukana endleleni ekusebenza ngayo Mamvithilingam noBaba Steyn ikona kwenza ukuthi kuvele kube kungathi khona ukwehlukana ngenxa yokuthi lokho kulethwa indlela abasebenza ngayo ngokuthi umehluko lona wenza ukuthi-ke kufanele ukuthi kube nokuchazwa kahle ukuthi yini indaba kube nalomehluko ngaka.
Further, the state argues that the crux of the matter also revolves around these two calls as reflected, one, in the PDF disk proffered to the state by Vodacom, and also what is referred to as the Excel spreadsheet, which encapsulated two different numbers, which are allegedly also supposed to have been sent or having been transacted between Kelly Khumalo and accused number 5. These numbers, as correctly stated by Mr. Nisi, they are dissimilar and they are materially different, or he says there are material differences. And also he goes further and says that difference, in his view, it was intended to pervert the course of justice. I'll leave it at that.
Kuthiwa-ke into-ke ebhekiwe lana ukuthi-ke kukhona-ke izingcingo ezabonakala lapha ku-PDF evela kwa-Vodacom naloko kubhawe kuloko kubizwa ngokuthi i-Excel. Lapho-ke izinamba ezimbili okuthiwa zakufonelana phakathi kwaKelly Khumalo nomsolo wesihlanu kugcine kwenza ukuthi kube nokwehlukana okwenza ukuthi-ke kube nobunzima ekutheni kwamukele ngoba egcineni kubonakala sengathi kunobukhwabaniso obukhona lapha.
It is correct that Ms. Pinky Wallingham was not able to explain the origin of the two numbers of the two transactions allegedly transacted by Ms. Kelly Khumalo and accused number 5.
Kuyikona lokuthi ngempela Mamvithilingam akakwazanga impela yacaca ukuthi akakwazanga ukuthi achaze ukuthi yini indaba kuneyinamba ezimbili ekuthiwa zakhuluma noKelly Khumalo zivela kumsolo wesihlanu.
And these two numbers allegedly were made at the very same time as alleged by Ms. Pinky Wallingham in the PDF disk supplied by Vodacom to the state or the police.
Lezi number ke za kwaba ingcingo ezenzeka ngesikhathi esodwa njengoba kusho uMamvithilingam njengoba kubonakala kule PDF eyathunyelwa emaphoyiseni.
And she says she can only testify on the numbers which are encapsulated in the PDF disk.
Uthi ke Ms. Wallingham yena ngakwazi ukuchaza kuphela ukuthi kwenzekani kulezi number ezivela kule lombiko wePDF.
But she cannot testify as to the numbers which are encapsulated in the Excel spreadsheet.
Jakakwazi ukuchaza lutho mayelana nenamba lezi sivela kule spreadsheet se-Excel.
Because those were not supplied by Vodacom.
Ngoba lezo inamba ke lezo ke akuzona ezalethwa uVodacom.
The numbers which were supplied by Vodacom are encapsulated in the PDF disk, not in the Excel spreadsheet.
Inamba
I don't know how the police or the state went about transposing those numbers onto the Excel spreadsheet. She doesn't know. Two different distinctive application of the two surfaces, the PDF and the Excel system. She knows nothing about that. But in this court, we know that, as Mr. Nisi states, there were two distinct numbers, two sets of distinct numbers relating to the two calls made allegedly to Kelly Khumalo by accused number 2 or vice versa.
Joke Vitilinga Mutiana, into ayichaza kuphela yilokhu okula kulombiko we-PDF akwazi ukuchaza lutho ngalokho kulapha kulombiko we-Excel ngoba lapha kubonakala ukuthi njengoba kuvelile phambi kwenkantolo kuneyinamba ezimbili ezehlukile ekuthiwa zazishayela inamba kaKelly Khumalo.
The state's contention is that not the allegation, the statement made by Advocate Nisi to the effect that there was fraud, there was uttering, defeating the ends of justice, or plain language, criminal activity intended to mislead this court and intended to pervert the course of justice, and consequently that charges would be laid or a complaint would be laid against even Pinky Wilthingham. And consequently the state is of the view that these are very serious allegations which must be investigated. The allegations ought to be put to Colonel Lieutenant Steyn, and that he must be given the opportunity to comment, because Pinky Willingham is being vilified on her own mouth. She's being vilified for an action or conduct which she never participated in. And I have said that amounts to reputational damage, because she's an expert witness. She gives evidence throughout the courts in South Africa. I first recall meeting her about 15 years back or so, or 20 years back in a criminal court. So I agree with the state when they say Steyn must come and account, because Willingham can't be
Kuthiwa lana kukhona ke okubekiwe lana ukubekwe ngokuthi ke umshushisi uthi ke manje lezi zinsolo zokuthi kukhona ukukhwabanisa okwenziwayo futhi okunobugebengu lokhu kuthiwa kwenziwe Miss P Vitilingam kuthiwa lokhu kuyindaba esindayo efaneleke ukuthi ke ibhekisiswe, and futhi ke kuyafanele ukuthi uSteyn eze azochaza ngoba lokhu phela kugcina kwehlise isithunzi sika Mama Vitilingam. Manje ke inkantolo yona iyavumelana nomshushisi ukuthi akabuye ubaba uSteyn ukuthi azochaza ukuthi yini inkinga phakathi kwalezi zitatimende.
Further, the state's contention is that this application is brought in order for Lieutenant Colonel Steyn to come and clarify the nature of these two calls.
Ke lokho uzama ukuthi ubaba uSteyn akeza azochaza ukuthi uhlobo luni lwazilezi ingcingo lezikhulunywa ngazo.
that accused number 5 allegedly is said to have made to Ms. Kelly Khumalo, that is, as to whether these calls were made using data or internet, or whether they formed part of incoming or outgoing calls regarding AMA data.
Kuthiwa ke lana ke ubaba uSteni ufanele eza azochaza ukuthi lezi ingcingo ekuthiwa zenziwa umsolo wesihlanu ziya kuKhello Khumalo zenziwa kusetshenziswana kwakusetshenziswa idatha noma kwakusetshenziswa i-internet noma ke kwakuyingcingo ezingenayo noma izingcingo eziphumayo yini.
And this court is also baffled, I can tell you that, by the evidence given by Colonel Steyn, because this is what he says under cross-examination.
Inkantolo nayo ididekile ngalokho okubekiwe la phambi kwale nkantolo nalezi ngcingo.
By Ms. Mshololo.
Njengalokho kulethwe umama Mshololo.
On the question as to how did he establish that the various numbers that he mentioned in his affidavit are being associated with accused number 5. And this is what he said. That is correct, but also, I can also mention, after I received the information from Brigadier Ginanda, I throw it into the I throw it into the AMB notebook database, and then the linkages come with the section 205s and the cell phone downloads. That's how he explains it. To me, it's baffling.
Into esukeke idito ukuthi njengoba ivesileyo no Brigadier Ginanda ukuthi hayi uvela athathe konke lokuthola lena akufake lapha ku-AMB notebook, and yona ke esizochaza ukuthi ukuxhumana kwalezi ngcingo kwenzeka ngaluphi uhlobo.
And he never explained how he goes about this.
Futhi achazanga ukuthi lokhu ukwenza kanjani.
It's like asking a Michelin chef in France, Paris, how does he prepare duck? And then he says, I throw it. I received the information from Brigadier Ginanda. I threw it into the AMB notebook database, and then the linkages come with the section 205s and the cell phones downwards. That is explanation. I don't understand that people group. I don't.
Hayi njenga lendlela okuchazwa ngayo kufana nokuyobuza umpheki wase Paris okuthiwa ilolu hlobo lweMichelin, ukusho ukuthi uchwepheshe omkhulu okupheka ukuthi umepheka ukupheka kanjani. Uma echazeni ukuthi vele ngithatha konke lo ngifaka emshinini lo we-AMB ebese ke ngithola imiphumela engiyidingayo.
So all the state says wants to happen is that Lieutenant Steyn must come and clarify the issue of the 2 calls, not to give new evidence. That's how I understand the application. And not to correct his evidence, to clarify his evidence. That's how the application is couched.
Manje ukuba umshushise ukuthi into ecelwayo nje ukuthi uLieutenant Steyn akeze azoletha incazelo, hayi ukuzoletha ufakazi obusha, futhi kungekona ke ukuthi azolungisa amaphutha, ukuzochaza nje kuphela.
So the state says it is essential to recall Lieutenant Steyn in order to clarify this aspect so that the truth can be determined in order for the court to arrive at a just decision of the case.
Ke yikho ukufanele uLieutenant Steyn ezazoletha incazelo ukuze ke iqiniso lizovela ukuze inkantolo izokwazi ukuthi ithathe isinqumo esinobulungiswa.
Okay, that is the gist of the application.
Kafushane ke isona ke lesi sicelo ekukhulunywa ngaso.
Now, Ms. Mchololos and the other counsel, if I'm correct, we try to define what are the duties of this court if it is approached or persuaded by a litigant, either the state or the defense, to say that because the court did not mero moto invoke 167, section 167, which I'll just read, and 186. I did not. I was entertaining an application.
Manje ke uma msholola zamile ukuchazela inkantolo ukuthi yini umsebenzi wenkantolo uma kuukuthi abanye babameli abala inkantolo befaka isicelo sinjengalesi.
Now this is what 167 says. The court may examine witnesses or persons in attendance. I'll just read it. The court may at any stage of criminal proceedings, at any stage, meaning even at this stage, even though I never invoked it. This is what I understand it to mean. The court may at any stage of criminal proceedings, meaning even during an application, like this one, examine any person other than the accused who has been subpoenaed to attend such proceedings or who is in attendance at such proceedings, and may recall and re-examine any person, including an accused, already examined at the proceedings, and the court shall examine or recall and re-examine the person concerned if his evidence appears to the court essential to the just decision of the case. And 186 says this, so that we keep that also in mind.
To inkantolo ke ithumi ichaza ukuthi 167 uthini yafunda inkantolo ethi inkantolo ingakwazi ukuthi nanoma ingasiphi isigaba so kuqhubeka kwecala ingakwazi ukuthi ihlole ubufakazi banoma ubani obebiziwe ukuthi azoletha ubufakazi la enkantolo uma ukuthi lo bufakazi bungaletha ubulungiswa ekuqhubekeni kokuqulwa kwecala.
Section 186 says the court may subpoena witnesses. The court may at any stage of criminal proceedings subpoena or cause to be subpoenaed any person as a witness at such proceedings, and the court shall so subpoena a witness or so cause a witness to be subpoenaed if the evidence of such witness appears to the court essential to the just decision of the court.
Jake section 186 yachaza ukuthi inkantolo ingabiza noma ubani ufakazi uma kuukuthi ufakazi balo ufakazi buyadingeka ekutheni inkantolo ifike esinqumweni sobulungiswa.
Okay. Sorry. Mr. Baloyi calls this application of his a rule of practice.
Babaloyi uthi ke lesicelo sakhe ke umthetho ohambelana nokuqhubeka kwendlela okwenziwa ngayo enkantolo.
Because according to him, it's not encapsulated as an application brought in terms of section 167 or 186.
Ngoba indlela achaza ngayo akusona isicelo esifakwa ngaphansi kwesigaba 167 noma isigaba 186.
Sorry. Sorry, so much stuff here. I quote Du Toit and De Jager in their famous commentary on the Criminal Procedure Act. At page 2-95, under section dealing with section 166, this is what the learned authors say. Recall for cross-examination. The right of the defense to recall a state witness for further cross-examination as part of a right to a fair trial was considered in S versus Rautenberg, 2014, 1 SACR, Johannesburg High Court, where the counsel wished to recall a witness because he had forgotten or had failed to put to a witness crucial aspects of an accused version for comment. This application was vigorously opposed by the state because, according to the state, the counsel's explanation for not having put these crucial aspects to the state witnesses regarding the accused version, the state held that they were not entirely satisfactory. But despite this, the court allowed the witness to be recalled. Bear in mind that I said cross-examination. But what Mr. Baloyi wants to do is to recall a witness for clarification. And how do you clarify? It has to be an evidential phenomenon. It's got to talk about how he clarifies it. And a witness can either be called to testify and then after he has testified, he is cross-examined, and after he's cross-examined, he can be re-examined. So logic tells you that this case of S versus Rautenberg 2014 is applicable here. 1 SACR GSK. It is by my brother and I dare say friend, Judge Bashir Vali. He was handling this case which regarded an accused who was charged with the murder of about 2 or 3 persons. He convicted this guy, and this matter was taken on appeal in Joburg, and I had the privilege of leading the bench, 3 bench. We upheld him, and they took us to the SCA, and the SCA upheld us. But this is what the learned judge has to say regarding cross-examination and examination and the recalling of witnesses. He says, recalling of a witness for cross-examination by accused counsel, who, in explaining that he was doing so as a result of the failure to put crucial aspects of an accused version to a witness. And he said, the learned judge, the right to a fair trial determined and demanded the recall of a witness despite the unsatisfactory explanation given by his counsel. And he says, this is so because the right to a fair trial is absolute and indivisible. Let me quote him again. The right to recall a witness, that right encapsulates a right to a fair trial, and it is accorded to the accused by Section 35 of the Constitution. And that right is fundamental and absolute. And it is not subject to any qualifications. And the right includes the right to recall witnesses for further cross-examination And by logic also, it entails the right to recall witnesses for further examination. Hence, despite the fact that the explanation given for wanting to recall the witness was not detailed enough and therefore not entirely satisfactory, the value in the application of this right was to be found in the duty of a court to ensure that the right of an accused to a fair trial is maintained in terms of its enunciation in Section 35 of the Constitution, and that it must be given its practical meaning. Because this right to cross-examination also includes the right to re-examination and to the right to the recalling of a witness if it is in the interests of justice. And also this right to a fair trial includes a right to clarification. And the right to an explanation with regard to the clarification of evidence. And this right also is encapsulated in the Constitution. I know people tend to talk of the Constitution as if it governs only the right to a fair trial as it pertains to an accused person. No, it also pertains to the state in having called witnesses. It's reciprocal. Section 35 as a right to a fair trial is reciprocal. And it was said also in the case of the National Director of Public Prosecutions versus King, 2010, 3 All South Africa, SA 304 SC. And it was enunciated by Harams. And this is what Harams had to say. He says the question, this is on paragraph 41. He says, it is well to remind oneself at the outset of a number of basic principles in approaching the matter. The Constitution calls for a generous interpretation in order to give effect to the fundamental rights and freedoms which it creates. The right to a fair trial is by virtue of the introductory words of Section 35(3) of the Bill of Rights broader than those rights specifically conferred by the fair trial guarantee therein, and embraces a concept of substantive fairness that is not to be equated with what might have passed muster in the past. This does not mean that all existing principles of law have to be jettisoned, nor does it mean that one can attach to the concept of a fair trial any meaning, whatever one wishes to attach the meaning to it. The question remains whether the right asserted is a right that is reasonably required for a fair trial. A general approach is called for. That is the question for the trial judge. And there is no general, not an a priori answer to the question whether a trial will be fair or not. Potential prejudice may be rectified during the course of the trial, and the court may make preliminary rulings depending on how the case unfolds, and may revoke or amend them. Irregularities do not therefore dictate that there is such a thing as perfect justice, which is a system where an accused person should be shown every scintilla of information that might be useful to his defense, and discovery in a criminal case must always be compromised. Fairness is not a one-way street conferring an unlimited right to an accused to demand the most favorable possible treatment, but fairness also requires that the public should also be represented and be treated with fairness. It is represented by the state, obviously. This does not mean that the accused's rights should be subordinated to the public's interest in the protection and suppression of crime. However, the purpose of a fair trial provision is not to make it impractical to conduct a prosecution. The fair trial right does not mean a predilection for technical niceties and ingenious legal stratagems. Because after all, this is a court of law where justice must be seen to be done. Further, the learned authors also, Du Toit and De Jager, say that the court has a duty to exercise the power to recall a witness where it is necessary to attempt to discover the truth in order that substantial justice is done between the parties. And they quote here the case of S. van der Berg, 1996, 1 SACR 19 is a Namibian case, and S versus Masowa, 2016, 2 SACR 22, Johannesburg High Court. It's a judgment written by Spelch, who still practices in this court. Further, sorry. Open that. I further refer to the case of S versus Gerbers, 1997, 2 SACR 601 SCA. It's a judgment written by Marais, J.A., who's famous for writing the judgment of state versus Malchus. This is what he has to say about the invocation of 166 and 186 of the Criminal Procedure Act when a matter comes before a particular court like today. And he says, by court in terms of section 167 and 186 of the Criminal Procedure Act of 77, the principles governing the exercise of such power, a trial judge is not a mere umpire, but is bound to see that justice is done, whether the exercise of a discretionary power favors the state or the accused. The Court of Appeal does not readily interfere with the exercise of a trial judge's discretionary power. However, a trial judge has to bear in mind that bona fide efforts to do justice might be misconstrued as undue partisanship, and the judge must ever try to find the right balance between undue judicial passivism and undue judicial intervention. The basic principles which govern the discretion of a judge under 167 and 186 of the Criminal Procedure Act is time-worn but remains as valid today. That is, it is time-worn in the case of R versus Hepworth, 1928 AD 265. But this law has not been changed right up to today. Still valid. And this is what the learned judge has to say about this time-proven law. A criminal trial was not a game where one side was entitled to claim the benefit of any mistake or omission. Harams calls it a predilection for ingenuity. By the other side, a judge's position in a criminal trial was not merely that of a mere umpire to see that the rules are observed by both sides. A judge has to see that justice was done. The power and discretion under these mentioned sections could be exercised by a judge, whether the effect thereof is in favor of the state or the accused person, provided that what is done is for the purpose of doing justice as between the prosecution and the accused. Further, the mere existence of those discretionary powers did not preclude a finding that a trial judge had exercised them irregularly, as that word was understood in the jurisprudence of criminal procedure. Nor did it follow from mere existence of a positive statutory duty to exercise those powers in circumstances where it appeared essential to the just decision of the case, that a trial judge's conclusion and that the circumstances were indeed such that these discretionary powers would be unassailable by a higher court. But basically what they're saying, once a judge has exercised this discretion, all he has got to do is to exercise a judicial discretion. Whether he's right or wrong, that's another story. That's why they say it would not be unassailable by a higher court, and that no matter what the circumstances might have been, his carrying out of what he perceived to be his duty could never constitute an irregularity. It's not me saying that. You can read this case. Further, a court of appeal should remind itself that there were well-known limits to its power to gainsay the bona fide exercise of a trial judge, whose discretion vests in judicial discretion with regard to the conclusion of a trial, that it was his duty bound, he was duty bound to exercise the powers under consideration. The Court of Appeal should not lightly substitute its own opinion, reached with the benefit of hindsight. And the learned court also says that there is obviously a potential tension between the need to fulfill the role of a judicial officer, as described in Hepworth's case, and the need to avoid conduct which was irregular and resulted in the failure of justice. Nevertheless, it remains incumbent upon all judicial officers constantly to bear in mind that their bona fide efforts to do justice might be misconstrued by one or other of the parties as undue partisanship, and that, difficult as it might sometimes be to find the right balance between undue judicial pessimism and undue judicial intervention, they have ever to strive to do that. Right? In this court, there was an exercise of the same power of the discretion by a judge. My brother Motata was involved in that case. I'll read it. Sorry, it's a written. Maybe some of us know that case, but this is what was said in that case. This was a case of the Director of Public Prosecutions, Transvaal versus Eric Pet Mchweni. This is case number 56/06. It was heard in this court, in this SCA by Judges Falam, Klute and Lewis. And this case also concerned ballistic evidence. But if you're interested in reading the full text, you can do so. But it's basically the following. This judge, my brother, Seriti, we were together at Forte, he misconceived and misconstrued the evidence where ballistic expert had said it was indeterminate whether this particular firearm had fired the projectile. When they examined that firearm, it did not have indentations imprinted onto the bullet. So this gentleman said his finding that this firearm was the one which was used to shoot the accused person twice on his face cannot be determined. It's indeterminate. And Judge Seriti wanted to know, the defense of this gentleman is that he was shot in Garangua, not here in Brits on a farm. Okay, there was DNA evidence showing that after he was shot, his blood dripped onto the yard, and the DNA obviously connected him to that. But this is what the judge says. 3 judges. In my view, it is clear from the record that Seriti J. did believe that the evidence of the ballistic expert was essential to the just decision of the case. And he acquitted Mchweni because there was no explanation of the inclusiveness of the finding. And the 3 judges says, he had a duty in view of his belief that it was essential to the just decision of the case himself to call the witness, like I'm called by the state to call this witness. Moreover, it is apparent from the passages of the argument quoted above that Seriti did not understand the import of the ballistic report. I don't understand that evidence of a stain saying he just mixes ANA, etc., and he gets the results. I don't understand it. Same thing with Seriti here. But he did not call for that evidence or explanation. So they say, moreover, it is apparent from the passage of the argument quoted above that the Seriti did not understand the import of the ballistic report. He said as much, as I'm saying as much. All the more so, therefore, that he had an obligation to call the witness in order to understand that evidence. He was obliged in terms of section 186, and thus as a matter of law to have acted in terms of the section. And this is the summary of the finding. Where the presiding judge at a trial believes, albeit mistakenly, that the evidence of a witness is essential to the just decision of the case, in terms of section 186 of the Criminal Procedure Act 51 of 77, it falls to call. If he fails to call such a witness, he makes an error of law. That's what they're saying I'll be doing. If he fails to call such a witness, he makes an error of law. If the error is one of which the acquittal of an accused tends, then there is a grave irregularity in the proceedings, and the Court of Appeal is bound to order a retrial on the same charge sheet. Here, a question of law was reserved for argument in the SCA. This is what the SCA says. You rather err on the side of being wrong. Here's a judge. He was confronted with a similar situation. He said, no, I'm not calling this guy. And then the state said, please call him so that he can come and clarify. Then they noted the point in terms of section 319. On appeal, they succeeded. Okay. Further, I just want to quote the other case and then bum 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 bum. Sorry. Sorry, I just want to sort out this case. Sorry. Yeah, in the case of S versus Ngobo, 1999, 3 Constitutional Court, although then they called it BCLR 298, but it was a Constitutional Court decision. It says, section 186, N versus Zages, in plain language, a partly inquisitorial approach. The court has a duty to exercise the power where it is necessary to attempt to discover the truth in order that justice be done between the prosecutor and the accused, so long as the questioning remains within the bounds stated in the case of S versus Roll, 1982-1. Yeah. Sorry, let's just do the last case now. Right, just to adumbrate the point made by R versus Hepworth. In this case, after the learned judges had quoted the case of R versus Hepworth, in the case which is unreported of State versus Ngobeni, 2014, it's a it says SCA case, it's unreported, but it is case number 741/13. It was heard on the 2nd of May 2014. Busielo J.A., who was my article clerk in 1982, in a dissenting judgment, accepted the dictum of Kerr Lewis J.A. in Hepworth and said that it is salutary because it introduces an inquisitorial element to a fundamentally adversarial criminal justice system. And he added that this was, however, intended to avert the possibility of an injustice which might occur should a court remain supine in the face of a need to be proactive and to obtain the necessary evidence. A court had nevertheless to be astute to avoid creating the impression that it has descended into the arena, which was impermissible and should result in this court getting involved in the dust of the conflict between the prosecution and the defense, with the concomitant loss of impartiality, an essential prerequisite for a fair trial. Busielo J considered that it was important to remind judicial officers presiding over criminal trials that there are times when justice demands that instead of remaining passive umpires, merely there to ensure that the rules of the game are observed, that they have to be proactive without compromising their impartiality, to call for the relevant evidence, particularly where they are of the view that such evidence is necessary to ensure a just outcome. This was also the opinion of the judge. And he says that is the reason, the trait of Section 186. So all the authorities are saying to me, listen, they're saying to me, I don't have to be supine. I've got to be proactive where I think that justice will fail if I don't make such, I don't entertain such an application. They are actually saying, I will be committing an irregularity. It's not me saying that. 5 judges of the SCA quoted to the case of Mchweni. So it's settled law that if it is within the reasons of logic, there is an argument between the state and the defense regarding whether evidence has to be corrected or clarified, or evidence in the administration of justice can never ever happen. They say the judge should err on the side of the application. And I've already conceded that I don't understand what Steyn was saying there. Never explained it to this court. I don't understand. And the state says it's not a contradiction. It is a misunderstanding, a misconception. So here we have a misconception, a misunderstanding, a contradiction, and a non-understanding, all from persons in this room. So why not call the person who is causing that very misunderstanding, misconception, to come and explain, and he's alive. And there's no prejudice, by the way, none. When he comes here and perjures himself, this court can even charge him with perjury, Steyn. If he comes here and perjures himself, there are criminal consequences. But it doesn't matter which way he comes and testifies. For this court, the truth must be told. And there's only one person who can tell the truth about this. It's Steyn himself. He's the analyst, not me, not Mr. Momalo or Mr. Baloyi. Consequently, the application is acceded to. Yeah.
May I just request to establish something after the order of the court,
Quite.
after the ruling of the court? In this clarification purpose, will it not invite new facts, because we are not sure what Steyn is going to say?
Yeah.
And I was appealing to the court to guard against new facts, because that will not serve the purpose
Yes, you're
for
right.
which Section 167
You're right.
is in. But please.
Mr. Mnisi says, actually, if it's all new evidence, it's okay. Is that not what you said, sir?
I just missed the court, madam.
You said if it's new evidence, you would understand.
I really did not mean it in that context.
Okay, fine. No, there are parameters to what Steyn can come here and tell us. He has already given evidence. He's just here to clarify. So it's not like he starts by telling me that he was an analyst employed by the Ruperts, blah, 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 blah. No. It's circumscribed. This application is circumscribed. According to Baloyi, it's on 3 aspects. Am I right, sir? It's circumscribed to come and clarify.
Indeed, my lord.
That's what you say.
Yes, indeed, my lord. But
So I'm saying there's no prejudice to anybody. This witness will be taken into cross-examination. Because like I have said, and as we all know, Ms. Pinky Thallingham knows nothing about that parcel spreadsheet. Knows nothing. She never participated in it.
As well.
Yeah.
In the light of the court's ruling and in the light of what I had previously asked the witness, Ms. Vitilinger,
Was it?
I asked Ms. Put a proposition, in fact, to her.
Yeah.
And my learned colleague, Mr. Sibanda, objected to say, Mr. Steyn didn't say so. Will that now be an opportunity also to
Yes.
clarify those aspects?
Yeah, you can.
I'm happy, my lord. Thank you.
Yeah.
I mean, that's it.
Mr. Steyn, Mr. Sibanda, and Mr. Baloyi are one and the same. Is that not so, sir? What is said by your colleague is said by
yes,
you.
indeed, my lord.
That's why
yeah.
mina nguBaloyi, I'm so Steyn.
We just want to point out that in clarification of those issues, there might be documents that will be used just to demonstrate, or to be used in clarification.
Yeah, no.
Yes.
It's a clarification. I don't know what Steyn is going to. Steyn is going to say. Me, I never understood him. You just take A and B and you do this and they come out. That's all he said. So he'll come and tell us exactly what he did. Okay.
Yes, if we may perhaps adjourn us, it's about 20 to 1, just to show the documents that Colonel Steyn will be using to my colleagues and just agree on the way forward. Maybe we can resume at 2.
Any objection? I don't have to see those documents. But he wants to show you those documents. Hello?
There are documents that the state would love to share with us, madam.
Yeah, I don't know what.
Yes, madam.
Lord, may I also take a minute just to summarize?
Yeah, summarize for the
Inkantolo ke ibhekile i-section 167 section 176 mayelana phela nokubuyiswa kokafakazi ebuyiselwa ukuthi ke azocacisa okuthize. Inkantolo ibheke lapha incwadi yabhala uDutoit noDiyaka mayelana ne-Criminal Procedure Act. Lapha ke kuveziwe ukuthi kuyabonakala emacaleni njengecala lika Rautenbach elaba segoli la ichazwa khona kabanzana ngokuthi ke inkantolo ingenzani bakhona okuningi okubekiwe enkantolo ukuthi cha inkantolo kube kwamacala amaningi achaza ukuthi inkantolo yibhekane nezimo ezinjena zolapho ekufanele khona inkantolo ibuyise ufakazi ukuthi azoletha ubufakazi bokuchaza futhi. So ke inkantolo wavezile amacala amaningi lapho amajaji ayeveza khona ukuthi inkantolo izobe ingawenzi umsebenzi wayo uma kuwukuthi ayilethi ufakazi ukuthi azoletha futhi ubufakazi ngoba lokho kuzobe kuletha ubulungiswa. Ngakho inkantolo ithatha isinqumo sokuthi lo fakazi okuceliwe ukuthi akaphinda abuyise uzobuyiswa enkantolo ukuthi azoletha lo bufakazi. As the court pleases.
Okay, so we come back at 2, is it?